Tonight, a crucial time for Oscar Pistorius, the final chance for lawyers to prove his innocence or guilt. The athlete's father makes his first appearance at the court to hear the closing arguments of the trial. And so does the father of Riva Steenkamp, joining her mother, who sat through months of painful evidence. Welcome to the High Court in Pretoria, where the prosecutor in the Oscar Pistorius trial has made a final push to convince the judge that the Paralympian is guilty of murdering his model girlfriend on Valentine's Day 2013. Today, in summing up, Harry Nell described him as an appalling witness who told a snowball of lies. He's also criticised the Pistorius legal team, saying they put forward more than one defence. But Harry Nell says the athlete only has himself to blame for tangling himself up in lie after lie. Alistair Bunkle reports on the day in court.
Harry Nell has been typically blunt in his analysis of Oscar Pistorius' defence throughout the trial. Today was no different.
The accused never said to anyone that got to the scene, that he spoke to, it was an accident. The shot just went off. He never said, I didn't want to shoot. He never said, I don't know what happened. He said, I shot Riva. I thought she was an intruder. We have 3 different versions already by the accused himself. I fired with intention. I thought they were coming out, and I discharged my firearm and was precipitated by noise. And before I knew it, I fired 4 shots.
Harry Nell then laid before the court 13 inconsistencies that he claims are part of Oscar Pistorius' evidence, what Nell calls his baker's dozen.
Number 1. The accused's answer to a question pertaining to the video is indicative of his evidence as a whole. Initially, he confidently testified that he has no idea what a zombie stopper is. I don't know. Let me just go there.
Nell referred to a home video obtained by Sky News. In it, Oscar Pistorius is seen shooting a watermelon, and then a voice which sounds very much like his calls the bullet a zombie stopper.
It's a lot softer than brain, but it's like a zombie stopper.
What's a zombie stopper? I have no idea what a zombie stopper is. Have you ever been in the presence of a person using the word zombie stopper? Not that I can recall. Have you ever seen a video of yourself in the presence of people referring to a zombie stopper? I've never seen a video of myself where someone in the video has referred to a zombie stopper. As far as I can remember, it's just a lie. The accused never thought that we would get to that video or would be able to show it. I started the cross-examination by referring to the clippers, the hair clippers that was plugged in. He said, yes, it was plugged in there. He plugged in the other fan was also plugged into that extension cord. I went on, and then, milady, I indicated to the accused that there is no space left for the other fan. Now, milady, his version is never that the other fan was plugged in anywhere else. His version was that he plugged that other fan into that extension. Then he had to adapt his version. Milady, the answer is just this. There, objectively speaking, was only one fan plugged into that extension cord, and it was that particular standing fan, no other fan.
Oscar Pistorius claimed in his evidence that the police tampered with the scene, moving the 2 fans, his duvet, and Riva Steenkamp's jeans. That never happened, though, said Harry Nell.
The inability of the accused to explain why the police would have moved the smaller fan into the corner of the room. They moved both fans, and in a display of astounding foresight, milady, they then threw the duvet onto the floor and created the blood spatter pattern from the carpet onto the duvet. The conspiracy is just too complicated and impossible, milady. he decides what's significant or not, because he's not giving the court the truth. He's thinking of defending his life.
Next, Harry Nell questioned Reeva Steenkamp's actions in the middle of the night, suggesting that Oscar Pistorius had made up a story about what she had been up to. The athlete listened with his head in his hands.
When asked, why did you not see her get up? He said it was pitch black, indicating that he tailored the version to indicate that she got up after he closed the curtains. He remembers that he had to remove the duvet out of the way when he got out of bed. It's such a clear tailoring of a version that the court will have, with the utmost respect, no option but to find that that's what he did. In his attempts to prevent the domino effect on the mosaic pieces, the accused changed his version. I could see the duvet going up. That is all I could make was a silhouette. I presumed that it was her legs. All these lies caught him up, because if he saw the duvet over Reeva, then he saw Reeva when he got up. But when he got up, he said he had his hands in his head in his hands. He never saw her. And to put the duvet back on the bed, he had to explain that he had to move it out of the way. He saw her silhouette. She was under the duvet. It was just so many lies in such a short period that the snowball effect became so evident. You tell one lie, and you have to continuously build on it, and it just becomes ridiculous. She did not open that toilet window. Why would she do that 3 o'clock in the morning, sleepy, wanting to go to the toilet? She did not, my lady. It's a figment of the accused's imagination. Why would she take a cell phone with her 3 o'clock in the morning? There is argument that there's indication in the WhatsApp that she did so before. It's true. But she spoke to the deceased, the accused. She's with the accused. Why would she take her cell phone with her? She didn't have to talk to the accused, WhatsApp the accused. He's standing in front of her, in the bathroom. He's shouting her name. She's in the toilet cubicle. She did not utter a word. Why would... It just gets ridiculous with the utmost respect. All these things the court will have to accept before the court can accept the accused version. Why would she not? He says, Reeva, phone the police. She's in the cubicle. He's in the bathroom. She doesn't say a word. My lady, no. For her, well, firstly, she got up from the toilet, or she was finished, or whatever. But she had to, my lady, got up and close that door. Because if that door is open and you're on that toilet seat, it opens this way, my lady. The toilet seat is there. You have to get up if it's open enough for you to go in. So she had to do that. So she had to get up, and on his version, she slammed the door shut. Because that's the second startle. We have to get to startles. It's not as if she thinks there's something wrong. She knows that the person that's a danger is standing in front of her. My lady, I think it's of utmost importance to be able to see the door and to realize that where A is her right hip. She is right in front of that door, in the middle of that door. That's not what a scared person would do, my lady. That's scared of an intruder. It is significant, though, that on the accused version, he has to explain the sounds and the screaming. He has to testify that he screamed whilst breaking down the door. Now, he would scream whilst breaking down the door, and then he would see her lying in a pool of blood. But he would stop screaming. His evidence is he never screamed after he saw her lying there. Now, my lady, normal human behavior would dictate that if you see your loved one lying in a pool of blood, and you just caused it, and you've screamed before that you screamed more than ever. But he didn't. He had to stop, because that's when the deceased stopped, when she was killed.
For 5 hours, Harry Nell relentlessly attacked Oscar Pistorius' defence, claiming it had glaring contradictions. He branded the athlete a deceitful witness and said his version of events was a mosaic of pieces that fell off the picture one by one.
If each piece of circumstantial evidence is weight, if the weight of each piece of circumstance is that of a feather, if you pile that on the scale, all the circumstantial evidence and all the feathers, my lady, the scale will convincingly balance in favour of the state.
Coming up, Harry Nell goes back over messages sent by Riva Steenkamp, which he says show she was at times unhappy and scared. Welcome back. Prosecutor Harry Nell has crammed 107 pages of his summary argument into just a few hours in court, insisting that Oscar Pistorius must have known Riva Steenkamp was behind the bathroom door.
She didn't hide behind a wall, or she was standing with a right hip at A. She's standing right in front of the door. She's not hiding. She's not scared of an intruder or scared of the accused shouting. She's talking to him. We may have had more difficulty in arguing what we're arguing if the accused emptied his firearm into the door and into the bathroom everywhere. He just started firing and never stopped. But we don't have that. We have 4 well-grouped shots by the accused. Somebody that's in control, not somebody that's not in control.
He then went over a neighbour's evidence, which contradicts Oscar Pistorius' account that his house was in complete darkness.
She's lying in a bed, she's fluid, she's contemplating, should I get up, should I do something? I heard 3 which sounded to me like gunshots. I immediately asked my husband, did he hear that? He said, yes, it was gunshots. At that stage, I was sort of sitting on the bed and could see the lights on. We have a credible witness saying when she woke up, she had line of sight of that window, and at that window where the red arrow is, the lights were on.
Harry Nell read out again some WhatsApp messages that Riva Steenkamp had sent to her boyfriend.
We're talking about the message 14 days before the murder. I'm scared of you sometimes, and how you snap at me, and of how you will react to me. I think it looks like we are a struggle, and maybe that we are. I just want to love and be loved. Be happy and make someone so happy. Maybe we can't do that for each other, of course, right now. I know you aren't happy, and I'm certainly very unhappy and sad. We have I'm unhappy 27 January. We have I'm unhappy a couple of days later, 7 February. So nothing improved in that time, and we know that that relationship ended when she was killed on 14 February. So, my lady, what I'm saying is, if one takes into account the time, the dates of these messages, that is important. And it's not a normal couple, it's not one of those normal relationships. This relationship ended in death.
And in his conclusion, Nell predicted Oscar Pistorius' downfall, saying it will be the athlete's fault.
We return to the metaphor of the relay race. If the accused started the race with a baton, and that baton he had to hand over to somebody, he wouldn't be able to do that because he stumbled and he fell and he dropped that baton. The baton of truth is not with him. He cannot complete this race, my lady, and he should only blame himself. If in a relay race you drop the baton, you're disqualified. The accused disqualified himself from his version being accepted by the court. If the court rejects the fact that there was a perceived intruder in that house, then The accused armed himself, got the gun ready, walked to the bathroom, shot and killed the deceased. Not in the spur of the moment. I mean, he had lots of time for reflection. He made up his mind in the bedroom when he armed himself. I don't know when he armed himself, but he made up his mind. That, my lady, is pre-planning.
There was just time for Oscar Pistorius' lawyer, Barry Rue, to begin his rebuttal of the arguments, and predictably, he went on the attack.
The state started off by submitting to this court that he's so reckless with the firearm. Look at September and look at January, and now, of course, again in February. There are two difficulties. The one is we refer in the heads of argument to the Bruins matter, saying, there was previous case Kanyapa and it overruled it, the Supreme Court of Appeal, to say you cannot take a conviction of the other counts into account for purposes of the murder in this case. You cannot do it, but we'll deal with that. So the state cannot do that. The second point is that it was to some extent called a presumption of continuance that the authors in all the books dealing with the law of evidence will work with and warn against that. And the state also very subtly tried to apply that. How the so-called presumption of continuous work was, you see a man or a person driving fast, and 2 kilometers further, you don't see him all the way. There's an accident, and a whole question then arose. Can you say because he was driving fast here that the speed was the cause of an accident later on? And there's a warning to say there must be a nexus between them. Unless you can have that nexus, you cannot apply that so-called presumption of continuance. And that's what the state really tries to do. He says, because of that, and because of September, and because of January, it must be February. You cannot do that in law.
Well, joining us to discuss the day's events are two specialists and experts in their own right. Cobus van Drooyen, a former acting judge and criminal lawyer, and Franco Visser, clinical psychologist. Cobus, can I turn to you first, because it was a day of legalities, wasn't it?
Yes, absolutely.
What do you think his whole case, the prosecutor's whole case, is hinging on?
Well, they're simply saying that you can't come up with this kind of defence and say that it's putative, defence, or even then say that you've been in such a situation where you can say that you didn't act. And in fact, the state pushed him into those two defences at a certain stage when he said, well, I don't know when I really pulled the trigger. And so it's something which the fifth-year students regularly fail. This is a very difficult thing. But the whole day was stacked with legal questions, and it's meant for the judge in the end. And one would also see the tone from the state prosecutor when addressing the judge, like world over this would happen. When they address this judge, they do it very tactfully. They no longer difficult.
The
tone
really
is a
changed,
friendly one.
And respectful.
Yes, very respectful, which that you would usually find in any case. But now is not the time to fight, but to put the case well. And I must say,
Terry Nell's catchphrase seems to have changed to "with utmost respect, my lady," and "snowball of lies."
Well, he's no longer prosecuting; he's pleading.
But the bulk of the day was spent discussing this document, which is the prosecution's written summary, goes to more than 100 pages, and it really all centres, as you pointed out to me, on this one sentence. The accused vacillation between defences is much like saying to the court that if you were not on the scene of the crime, but if the court finds you were, then you rely on an additional defence, that of self-defence.
Well, that wasn't really what he said. He said, when he was pushed in this position, he said, when I pulled the trigger, I wasn't really willfully pulling that trigger. Then he said to him in a cross-examination, but you can't say that. How can you're saying that it was putative self-defense in the sense that you thought it was someone who had broken into the house. How can you now say, leave it to the court, that if you find that I was call it, awake, then my defense will be putative self-defense. You can't do those, but he can, to my mind.
Oscar Pistorius' demeanour in court, Franco Vissa, has often been the subject of much discussion because he's been sick, he's been nauseous, he's sobbed, he's cried. Today he was displaying another different emotion. He seemed to be yawning an awful lot.
Yes, that was quite evident from the start of the day that he was yawning, and in fact, it's a very tricky thing because the message that he can give across to the bench is that either he's exhausted, tired, which he might be, especially in highly stressed circumstances such as this, or that he's bored and disinterested.
And what about the crux of the defence's case, which is what was going through his mind, what was in his mind as he went down that corridor, as he held the cocked gun, as he advanced towards danger? Yeah. From your observation of him and his background, what do you make of that?
I do think in the whole process of this court case, it's a repeat trauma for Mr. Pistorius. It's a possible repeat trauma. Especially now when things are summarized and, the essence of the case is arrived at. Hearing all these things yet again, puts him in that spot that night where this event occurred. So going through his mind is, yes, is this correct? Yes, is this not correct? Reliving, re-seeing in his mind, things that happened, might not have happened.
Well, Franco Vissa, Cobus van Rooyen, thank you both very much for your specialist views. I'm sure we'll be turning to you again over the next few days. 5 months after it started, tomorrow will be the final day of this long overrun trial, with the defence concluding its argument. There is no jury in South Africa, so the verdict hinges on whether Judge Masipa believes Oscar Pistorius' version of events. If she doesn't, he could be jailed for life. That's it from Pretoria for now.